Good morning. Welcome to our latest installment in our webinar series, Greenbroy, Letton, Wheeler, Our Method for Success. How did you win that case? I'm Scott Carr, and I'm a partner at Greenbroy, Letton, Wheeler. We have a fantastic program for you today. Be sure to sign up for our next program, which is on October 1st, where Rob Jarchi and Christian Nickerson will discuss the Padilla versus Southern California Edison case involving electrocution to an undocumented farm worker from overhead power lines, which resulted in a $4.7 million all general damage verdict. So a lot of interesting issues in that case that I think you'll really be helpful for you in your practice. But our program today is focused on an extremely timely and interesting topic, sex abuse. With all the recent changes in the law, I'm sure you'll learn some practice tips from our amazing speakers on our panel. The way that this is going to work today is that I'll introduce our panel, both of whom have substantial expertise in this area. I'll then give you a brief overview of the TH case, which is a school sex abuse case that the discussion will be framed around today. Taylor and Holly will then give you a summary of the existing law, including the recent changes to the law, to help you navigate through this maze on all your cases. They'll then take that framework and apply it to the facts of the TH case and discuss some of the evidence that was developed there. Finally, we should have some time at the end for some questions. So type your questions on the question line to the right, and we'll get to as many of them as we can. So let's get started. Our first presenter is my partner at Greenbroy, Letton, Wheeler, Taylor Rayfield. Taylor graduated from the University of North Carolina in 2005, where she also set national records as a volleyball star. She went on to obtain her JD from Loyola before joining Greenbroy, Letton, Wheeler. Taylor has established herself as one of the leading attorneys in California on sex abuse cases against school districts, police departments, and other organizations. She's won many accolades, including being named as a top 100 up-and-coming lawyer in Southern California and a top 50 up-and-coming woman lawyer in Southern California. She served on the board of CALA and as both education chair and chair of the Las Vegas convention for that organization. Most impressively, Taylor was named Street Fighter of the Year by the Consumer Attorneys of California for her passionate commitment to victims of sex abuse based on her work in this very case. Our next presenter is Holly Boyer, a partner at what I would say is the best appellate firm in California, Essner, Chang & Boyer. Holly's a graduate of the University of Arizona, and she received her JD from Southwestern. Holly has written countless articles for CALA and CAOC, has taught at Southwestern, and is a frequent lecturer on issues relating to appellate advocacy. She's a top 50 women's attorney in Southern California and has been named a top 100 lawyer in Southern California by Super Lawyers. Despite all of these accolades, Holly is most proud of the work she has done to advocate for victims of sex abuse. Her published decisions include the seminal case of CA versus William S. Hart Union High School District, which you'll hear more about in a little bit, and Janice H. versus 696 North Robertson LLC. Most recently, Holly helped draft revisions to California sex abuse law for the legislature and testified in support of that legislation to provide justice for victims of sexual abuse related to Dr. Tyndall at USC. I can go on about both of these outstanding lawyers, but I'm confident that their presentation will speak for itself. So what is this TH case about? Let me just tell you a little bit. In 2014, TH was a freshman at Torrance High School, and he was on the wrestling team where Thomas Snyder was the head coach. TH was required to participate in skin checks in which Snyder required him to stand nude in front of him while Snyder examined his genitals. At one of these skin checks, TH was asked to lift up his penis. Snyder also gave plaintiff a hernia check, and during so put his hand inside plaintiff's boxers and touched the plaintiff's genitals. During another instance, Snyder had plaintiff remove his clothes and lie on a bench so he could massage plaintiff's groin area. He also gave plaintiff another massage in which he had plaintiff lie on a bench with his boxers on, and Snyder went under his boxers and touched his groin area. Plaintiff was also required to shower after every practice, and Snyder would sit in the middle of the room and stare at him and the other wrestlers as they showered. Ultimately, Snyder was convicted of 26 counts of lewd acts upon a child 14 or 15 years old, 3 counts of felony lewd acts on a child under 14, and 8 misdemeanor counts of child molestation. He was sentenced to 64 years in prison. Specifically, with regards to TH, he was convicted of 3 counts of Penal Code Section 288C1. But that's not the end of the inquiry. In these cases, there is no respondeat superior. So in order to hold the school district liable, in layman's terms, you have to prove what did the district know and when did they know it. Here, through tenacious discovery by Taylor, evidence was uncovered that the district knew all the way back in 2004 of allegations against Snyder at a time when he was a technology teacher and assistant wrestling coach in the district. Despite their knowledge, the district did not report the allegations, despite their mandatory duty to do so, did not investigate the allegations, but instead simply informed the perpetrator himself about the allegations against him. Following these allegations, no action was taken against Snyder by the district. Instead, without any background check or determination as to whether he was qualified, spoiler alert, he wasn't qualified to be a wrestling coach, they hired him in 2014 as the head wrestling coach at Torrance High School. In fact, they never even looked at his personnel file, which likely would have uncovered the prior allegation of sexual abuse. Taylor will show you some of this evidence in her presentation, but I just wanted to give you all a general overview of the facts. So with that being said, take it away, Taylor and Ollie.
Thanks, Scott. So so we will definitely be talking a little bit about that case. Something that, is important to know is that we had one of the victims, and it was John Manley and Ron Labriola that had all the other victims. And so we kind of, both of our firms worked together on these cases. And so that's what, allowed such a great result. So I'm so happy that, we were able to work together on those. And I think too, the other thing is that this case happened before this new legislation came out. And so I think the way that Holly and I have decided that the best way to start is really to talk about where we are today and what we can do today with the new legislation and what it's given us, because it's given us so much more than what we had. So I think that's how we're going to start, is kind of just how, if you're today and you're sitting in your office and a new case comes in, how do you even look at it? What statutes apply? Like, what defendants are even available? Things like that. So I think that's Holly and I's plan today, and then we'll show you some of the little juicy evidence that we did get in this case. So if we could go to the next slide, please. So case comes in your door. All right, how are we even going to decide whether or not this case is worth taking? And let me tell you, there is nothing more horrible than when you're listening to these sex abuse cases and what these survivors have gone through, and you're sitting there in your head trying to check off the elements of, has the statute of limitations been blown? Has the government claim been blown? Is this a defendant that, there'll never be a single dollar that comes out of it? Is there something hinky about the client, and it's so hard to have to turn those cases down. I hate it, to be honest. I don't like having to do it, but it doesn't do your client any good, or your potential client any good, to take on a case that they're going to be re-victimized. If you're not honest and upfront with them and say, hey, look, there's a big statute of limitation issue here, and maybe there's some things that we can try to do, but it's not going, we don't think we have a good chance at this. And for anyone who hasn't done it yet, who's doing sex abuse cases, you should really look into the trauma-informed advocacy. And there's lots of different programs on it that'll kind of teach you how to be the best advocate, because you have to understand that a lot of these survivors have been massive trauma to them, and for sure have PTSD or trust issues, things like that, because they've been victimized. And so for you to take on a case, you have to understand that, and you have to be able to communicate with them and be honest Otherwise, they're going to feel like you have re-victimized them again. And we can't be doing that. I mean, these people have definitely gone through enough. So enough of my pulpit preaching. So let's start with statute of limitations. If we could go to the next slide, please. So, and the next one, please. So this is Holly's wheelhouse. For anyone who does not know Holly, and if you have a sex abuse case, she is the person that you need to be calling. She can help you from everything from, if you fall within the statute of limitations, if maybe there's some other arguments that you might be making, if the judge has made a bogus ruling, she's going to be your appellate lawyer. She's truly, truly the best. And this is for sure her wheelhouse. So Holly, why don't you give us a little overview about this new amazing statute that we all now have for people who were under 18 when they were abused?
Yes. Okay. Thank you. And good morning. And yeah, I want to dive in. So we'll talk about 340.1. And to talk about that, we need to start with Assembly Bill 218, which was just passed January 1st, 2020. This bill, like you've heard, did amazing things for victims. It significantly expanded the statute of limitations. It made it retroactive, which is a huge hurdle and really hard to do. It imposed treble damages for a cover-up, and it got rid of government tort claims for children victims of sex abuse. So I want to kind of talk a little bit about kind of the breakdown of the statute of limitations. But before I do, I just want to kind of chime in on what Taylor was just saying, because I think, I want to spend some time really acknowledging what has happened, which is amazing. Like California, for the longest time, we kind of had some wonky statute of limitations rules when it comes to child sex abuse. Other states were bypassing us. And so I really am proud of all of your work, all of the work of these plaintiffs' attorneys who have been fighting for victims, because it's been gnarly. Like, as you guys know, as Taylor and Scott know, we've had cases where, the old statute of limitations, specifically under the Government Tort Claims Act, the way the law was written, you would have to file a government tort claim within 6 months of the last molestation. And there's no tolling for minority. So that means like a 6-year-old who's sexually molested at school would have had to known that was abuse, told his or her parents. Their parents would have had to have the wherewithal to contact a lawyer and file a claim within that 6 months, or be barred from bringing your action, which is nuts that was even our structure, right? And I know for the longest time we kept trying to explain to judges, hey, sex abuse looks different. This isn't like a car accident where you immediately know, oh, I have a broken leg, oh, it's that guy's fault. The tort itself, by its nature, is one where you have manipulation, you have, a lot of times you'll have threats, like don't come forward or I'll do this. You have shame, you have embarrassment, you have the feeling of the victim of, was this my fault? Did I do something? Especially in kids who have no idea what this, what sex is. So what I think is so astonishing is that through this AB 218, which, I will admit, I spent a lot of time doing this. I know all the cases, see the law comes through. When I saw the draft of this, I thought there is no way this is going to get passed, because it has so much good stuff. And it just went, and it had momentum. And I think because of all of the attorneys out here who are fighting for these victims and bringing it to light in the news, I think because of all of that and everything that's happened and victims coming forward, it was an easy sell, because people are kind of really starting to recognize what this tort looks like and how hard it is for victims to come forward. So, so currently, for the law is 340.1 prescribes the statute of limitations and the procedures for bringing a claim for childhood sexual abuse. It currently says that if you were abused as a child, the statute of limitations, you can bring the claim all the way up into your 40th birthday, or 5 years after you make the connection between your psychological injury and the sex abuse you suffered as a child. So it's kind of discovery rule, but it's a little modified. So it's the causal link. And it's either until you're 40 or 5 years, whichever is later. And it's not just when you make the connection, it's not a subjective test, it's an objective test. So when a reasonable person would have made that causal link. It applies retroactively, which is huge. It also includes a 3-year revival provision. And what this means is that if your claim had been previously barred, so let's say you were sexually molested in the 80s by a teacher, and you never brought a claim, but when you went to go talk to a lawyer, they said, oh, your claim is barred, you know, all these different reasons, right? Statute of limitations, didn't file a government tort claim, etc. So you never pursued an action. You now can pursue that action during this 3-year window. And also for those victims who never made the connection until now, you now get the benefit of the larger statute of limitations. So it's huge. And so with regards to if you're over 40, the way the law is written is that back in the early 2000s, when all the church cases were coming out, they, because of the legislation and different interests, the thought was, okay, if you are over 26 at that time and going to bring a sex abuse action against a church or a third-party entity, you got to have a little more, because you got to balance this out with the fact that we're going after these third-party entities. So we're going to impose on you a higher notice, a heightened notice. And under the old law, it was really hard. It was basically you had to show, Taylor knows, I know we had these cases together, and it was gnarly. You had to show that the third-party entity knew or had reason to know, which is harder than constructive notice, that the perpetrator had committed an unlawful act of sex abuse before, and you failed to take reasonable measures to prevent that from happening again. So you basically had to show that this perp had molested someone else and the entity knew about it, which, if you think about, is insane that we would permit things like, daycare centers or AYSO or whatever these third-party entities are, schools, to say, hey, if you knew that he molested somebody, you could still hire him, you could still have him on board, but just try to prevent it from happening again. I mean, that's so.
It was it basically gave them like the one free rape rule. That's basically what it was like. Is like you could have someone do a one free rape and then ratify the conduct by being like, okay, like I guess we'll just like try to prevent this from happening in the future, and not taking any actions. And then it was like, oh, okay. It was crazy.
Yeah. So, and then it was just an oddly worded provision. It was tough. Defendants went bananas on the heightened notice. I mean, people would say, you had to actually see somebody getting molested to know, and it was just like, what planet are we living on? So thankfully, the way the statute was revised as of 2020, and Taylor's got the language right here in the slide, is that if you are over 40 and you're falling under this 5-year delayed discovery rule nexus, then you need to show, if you're suing a third-party entity, that the entity knew or had reason to know or was otherwise on notice that creates a misconduct that creates a risk of childhood sexual assault by an employee. So it's much more forgiving. It's just more of like foreseeability. Did you suspect? Did you know? It's more than constructive notice that this misconduct was there. Or, and this is really amazing, then the language used to say and, they changed it to or. So now it's or the person or entity failed to take reasonable steps or implement reasonable safeguards to avoid acts of sexual misconduct. This to me is the golden ticket, right? Because if the second half of that provision basically says, if it's foreseeable that there's sex abuse within your entity, you have to do something. No longer can you just do the ostrich, like stick your head in the sand, be like, no, I didn't see anything, I don't know about sex abuse. You have to actually take steps to prevent it, take steps to protect against it. So I think that latter part of that provision will really help in these third-party entity cases and makes
Molly,
it.
Question for you on that. So with this or language now, so where it's saying that they failed to take reasonable steps or to implement reasonable safeguards, wouldn't you say that that's pretty much the same situation that we have to prove anyway against our entities, even if, you know, we're bringing it with you are under 40 years old. So let's say you're 20 years old, you're filing under this statute against an entity. Like, to even get to past MSJ and to even get, you know, the check mark on the verdict form, you have to show that they reasonably knew or should have known this, like, foreseeability. So do you think that, you know, these cases, these Jennifer C cases, not Miriam, but these other cases, yeah, MW cases, is the same standard as it would be for this, the 5-year delay discovery?
So I think in practical application, yes. You know, I think we can argue that for sure. If I were on the other side, my response would be, well, this provision has to mean something, right? The legislature put it there for a reason. We know that it came after the church cases in the 2000s to kind of balance out this idea that we have an unlimited, you know, potentially statute of limitations. Somebody can make that causal connection when they're 95, right? So it's got to mean something. So I think I would say it's got to mean something a little more than notice, but the way it's written and with that change of the word and to or, I think you got a good shot at saying that, relying on the same evidence to say, hey, you didn't do anything. There's no steps to prevent anything. There's no safeguards. So I don't know how it's going to play out. I haven't seen any cases, any appellate cases on this provision, but I think you're right. I mean, I think there's enough wiggle room in that provision that we can use the same evidence we're already gathering to support that. So yeah, I mean, it's really, because that and used to be really hard because you'd have to show both, and it's tough, right? So so it's definitely helped there. And then, like we talked about, the revival window, the 3-year revival window, that is really huge. And especially with everything going on now in 2020, I think we're they didn't even know this was going to happen, obviously, with COVID and everything. But now we've got some time to vet these cases, to see, okay, is this something we want to take on? And for the victims to think, do I want to come forward now that I have this window? So that revival window and the retroactive application, which, you know, we'll talk about a little later about the government claims and how that affects that. But yeah, the 3-year revival and the retroactive application is huge. One thing I do want to touch on, so the revival period does not apply to claims that have been finally litigated to finality. And what that means is, if you sued under the old law and you went through trial and you either were successful or not successful, or even MSJ, right? And then you appealed it, you went through all the steps, and there's no more steps that you could take at the end of that. That's finality, right? There is no further action you can take to challenge that judgment. So that's what that means by finality. In that case, you don't get the benefit. You know, generally, there's always exceptions, but you don't get the benefit of this new statute of limitations.
Holly, would that be true even if the basis for the finality was the statute of limitations?
So there, like I said, there's always those like, so I would say in the old version of the law, there was an argument about that. And maybe that you remember that it was like in the 2000s, those church cases. And the way it was written at that time was that there would not be finality if it was based on a technical defense, such as statute of limitations. The current version doesn't have that. And the reason that is like that is because there's issues with separation of power for judiciary and legislature, and whether or not the legislature can revive final judgments, which is a judiciary branch area. So there's a little bit of, I would say generally, if your case is to finality, whether statute of limitations or whatever, I would say generally you cannot come under this new statute. That said, there's always exceptions. Call me if you think you have something, call Taylor, call Scott, you know, we can work it through, but generally that would be the rule. But I do want to highlight that, let's say you had a sex abuse case, you know, from 4 years ago that you lost on an MSJ on timeliness or something like that, and you've been kind of trucking in the Court of Appeal, and you have a Court of Appeal decision, but you're still within that time where you can petition the Supreme Court for review. that case is still pending. So therefore, that will be revived by this new statute. So just be aware that even if you lost, if there is still time to appeal that, which is, generally 60 days from the trial court judgment, you're not out of the water. You can use the benefit of this new statute. So,
and I was just going to say too, and don't forget, if you're filing under this revival window, even though it's kind of funky the way it's written, you still have to comply. Well, it hasn't been ruled on yet, but I just think it's easier to comply with the rules of filing if you're using the 5-year discovery rule. So if you're over 40, while I would argue that because there's a revival window, you're actually filing as if you were under 40, it's not worth the battle in the courts over it. So you have to just look at their special filing rules. You have to do like the certificate of merit, you have to file them as a doe. So just make sure you see that, and just let your clients know about that. Now, Holly, I don't know if you've seen it, but with COVID and everything going on, and see, in New York, they set up special courts for the new statute that they passed, whereas here they haven't done that. So I think a lot of judges are seeing these cases for the first time and they don't quite understand. So I don't know how long it's going to take for them to get these doe complaints and to then give you the permission to go serve the defendant. So it's something that, I think is just going to take a while, and especially now with the backlog of COVID, and especially if you're getting into the hub in LA County. So I would just say, make sure you're kind of calendaring these things for yourself, because it might end up, we might have to be going in ex parte and saying, hey judge, hey, can you just give me permission so I can go serve these defendants? Holly, I don't know if you've seen any of this happening yet with your stuff as well.
Yeah, I haven't seen, because I'm not usually on the ground filing the complaints, I haven't seen the stuff with the does, and I kind of tend to agree with you where it's like, it's a little fuzzy whether or not you have to comply with those if you're falling under the revival portion. But to be safe, I would, just to, not, follow the rules and all of that. But yeah, I don't know how that's going to pan out. And I think, one thing to be aware of is, while at the beginning we talked about how California is now coming on board and recognizing kind of what this tort looks like, there are still a lot of judges who don't see this that same way, right? So when they see a case and they say, oh my God, this is for sex abuse that happened in 1985, like what the hell are you doing? Like, I'm throwing this out. We got to make sure that we educate the court in all the papers. So if you're doing a demur, a summary judgment, whatever it is, we got to make sure we are laying the groundwork. And a great resource for everybody is the legislative history of AB 218, which is available online. And you can tap into that and kind of cite those statistics, those that they cite in the legislative history that concerns how these victims process it. Because, we're constantly teaching and learning, right? And we need to make sure that the courts don't see our case, see that you want to go after a church for sex abuse in 1980 and just want to throw you out whatever way they can. So I would suggest using some of that language, or, highlighting that.
Yeah, I totally agree. I think whenever I'm filing papers, and I think Holly, you might have taught me this back in the day when we first started working together, I feel like half of my papers is just educating the judge, because unfortunately, our judges are dealing with so many different statutes, causes of action. There's just so much out there because they're not, focused judges, so they're dealing with so many different cases that, I try to do my best to be like, all right, like, let me show you point 1, point 2, point 3, like, let me give you the framework so you can copy and paste that into your tentative ruling, just because, a lot of times we do this every day, so we just assume that everyone knows it. But, as we've seen time and time again, sometimes just people don't know. So.
And one thing to pick up on that is that as you're writing these demurs or dealing with the Doe Amendment, one thing to remind the court that I always think is really helpful is to say, we're just talking about opening the door to these victims. We're not talking about them winning. So if you have a prickly judge who's like, this abuse occurred so long ago, how are you gonna, like, this is ridiculous, you'd go after this entity, you can kind of calm those concerns by saying, hey, these statutes that we're talking about is just getting us into the door of the courthouse. We still have to prove our case, and we realize all of these hurdles with what's all the dumb stuff, witnesses, you know, get lost, memories fade, all those things that they like to say. It's like, okay, we'll deal with that. We have the burden. That you're right, you know, but at least don't shut the door now.
Yeah, the box of documents that mysteriously ends up in a fire somewhere. Yeah, absolutely.
Yes.
Yeah. Okay. Well, all right. So I think that's a really good overview of the 340.1 for if you're under 18. So now let's jump into the adult, which the adult statute of limitations is a little wonky and a little more, I would say, kind of nuanced. And so again, not to burden you with all the details, but Holly, I think you're, again, kind of the best person to kind of address some of these nuances, but I think it's important that we tell everyone who's listening, there is so many different aspects to this. So, you know, this is just the like 30,000 viewpoint. So, you know, make sure, don't just look at this and be like, okay, we're done. There might be some other nuanced ways to still bring your case.
Right. So I think with 340.16, what this is, and this was passed in 2018, I believe, and became effective 2019, January 1st. And what it says is that if you commence an action after January 1st, 2019, for, I think the way it's worded is like sex harassment, sexual, it's kind of harassment plus. But anyway, for an adult, then you get 10 years from the last act, or 3 years from discovering that nexus, right? And it's whichever one is later. It's not retroactive, and there is a provision that revives claims for the Dr. Tyndall sexual abuse. So it's it doesn't specifically say USC victims of Dr. Tyndall, but that's what it's geared towards. So you may be able to fit in there if you have something similar, but it's pretty specific. The only catch I want to say with this one is that and this is kind of how statute of limitations work anyway. If your claim, let's say, so this became effective January 1st, 2019. So from there forward, any sex abuse, you get this new statute of limitations. But let's say you have a case where a client was sexually abused mid-2017, right? So this is a year and a half before the statute came into play. Well, then for that analysis, what you would do is say, okay, what was the statute of limitations at that time? Which I believe is 2 years, right? Just normal personal injury. So you'd say, okay, you had 2 years. So your claim was still pending, meaning it wasn't expired by the then existing statute of limitations at the time this new one came into play. So you get the benefit of this bigger statute of limitations. So, you know, like Taylor said, this is like a very surface analysis of these statutes, but I just want to kind of flag a couple things so that if someone walks in your office and says, hey, I was sexually abused, and you look at the date and you say, oh, that's 2017, that's 2018, that's before this new law, you're out. There could be something where the claim is still pending. And as Taylor touched upon, in addition, you know, like in every case, in addition to statute of limitations, you can have arguments of estoppel. You can have arguments of delayed discovery, common law delayed discovery. You can have some of these other things that will kind of help. Estoppel, like we talked about in these cases, usually presents where the perpetrator will threaten the victim, right? And say, you know, not even like with violence necessarily, but with something like, if you tell, I'm going to tell everybody that you're, you know, whatever, or that you did that, you know, like these threats that will prevent that person from coming forward. And so there are other ways that you could try to make sure your claim is timely or prevent the other side from arguing untimeliness.
Yeah, there's never just look at the date and say, okay, we're done. There's definitely ways to get, you really want to get the full picture of why they didn't come forward and what happened and what the situation was. And then there's a lot of different kind of nuanced deep dives that you can look into. And that's That's why you call someone like Holly. That's what she's there for. She'll help you because she's going to be the one that's writing those papers for you when you have to argue those nuances. At least if you're like me, I do it. I prefer to go to the expert. I think it's the best. So let's move on to the next slide. Okay, so government claim, the bane of all of our existences. It's so stupid. At some point, I swear, I think all plaintiffs' lawyers should come together and we should do anything possible to get rid of government claims. There's no reason why a government should be able to get some kind of windfall because you don't bring something within 6 months. I mean, that's the whole point of statute of limitations, is to prevent people from coming back 100 years later and claiming something. So this whole government claim thing is a nightmare. But anyway, as kind of Holly talked about, and I'll let her flesh it out some, it has been abolished under 340.1. So if you're under 18 at the time of the abuse and you're bringing that claim under 340.1, you do not have to file a government claim. But so I want to make sure that I don't misstep and say something wrong. Holly, why don't you kind of give us kind of the quick and dirty about government claims if you're under 18 or if you're an adult for sex abuse cases?
Sure. Okay. So thank God for AB 218. So this also revived claims that had been previously barred by the failure to file a government tort claim. The bill also amended Government Code 905M, and I think R or something like that it added. And basically what it did is there had been an ongoing dispute, as I know a lot of you that practice in this area know, about in 2009, there was an amendment that said, hey, any sex abuse after 2009, you don't have to file a government tort claim, but if it's pre-2009, you do. And there was some really unjust cases that were coming out, like Shirk was a Supreme Court case where you would have the situation where somebody, just because the teacher was at a public school where you had to file a government tort claim, they could not bring their action if it was before 2009, but somebody at a private school could. And so there was all these kind of like, why are we treating these people differently? Why are we treating these entities differently? And so when the legislature passed AB 218, they did away with all government tort claim filings for child sexual abuse. So I would say that pursuant to 340.1 and Government Code 905, you are exempt from filing a government tort claim for childhood sexual abuse. With respect to, and that goes, so just a note, and hopefully we're not getting too in the weeds, but there used to be a dispute. Taylor knows I can do this pretty easily. So there was a dispute about, well, what if a local entity has their own local requirement that you file a government tort claim? Which is bananas to me, that you would, as a victim, have to like march on down to the local, entity
District office, yeah,
for a reminder and be like, oh, there it is, I have to do this, right? But there was a dispute about that. I believe that these new laws, and this is my opinion, so I don't know, we don't have a court of appeal necessarily confirming it, but I believe these new laws do away with that. It is you are exempt from having to file a government tort claim. So that's for children, for people abused as a child. For adults who have been sexually abused, the rule is the same as it is for any other tort where you have to file a government tort claim. So I would say you are still bound by having to file a government tort claim. I would say there are some arguments, and definitely talk to people, try to think about it, about trying to present something that says, well, because that accrual date should be triggered the same as your statute of limitations, I get this longer period instead of just the last, sexual act. So there's some arguments there. So, look into it. There's also, as we know, there's a provision in the government code, I believe, that says you don't have to file a government tort claim if the defendant is the regents of California, so like the UC schools. So there's kind of weird things like that. So just kind of be aware, do some research about government claims, but generally, if you're over 18, you do have to file one.
And this too, like as Holly was just saying with regards to statute of limitations, this is where also you can look at estoppel arguments. So for example, Holly and I were just working on a police case together where, you know, she was afraid to come forward. She didn't want to come and say anything because the police officer was stalking her and showing up at her house and doing weird things. And so she was scared that if she had said anything that, you know, something bad was going to happen. And so you can use those type of estoppel arguments, you know, oh, don't worry about it, don't file anything, like we'll take care of it. And then, you know, you've passed your 6 months, or there's lots of different rules for estoppel, because remember, statute of limitations is a defense. So there are ways to prevent that defense from coming forward, or defeating that defense. And as well, don't forget about substantial compliance. So that's the other thing that Holly and I was just working on as well too. I had a client who wrote a letter to internal affairs complaining about what had happened to her with this cop. And so we were arguing that, in fact, that letter substantially complied with the rules of the government claim. So it doesn't have to be some formal letter from an attorney or anything like that. So just make sure you kind of figure out all communications that your client had. And so that might help, you know, get you past the government claim as well. So just kind of keep all those things in mind. And if anyone's asking, luckily we didn't have to have that ruled upon because we were able to settle the case. So I don't know if we would have won that argument or not, but I felt pretty good about it. So we'll see. All right, let's move on to the next slide. Okay, who's the defendant? So this can get kind of tricky, you know, especially with these revival cases. So you're looking at abuse that happened back in the 80s. Okay, well, does that defendant still exist? I mean, how are you going to bring a claim against someone that still doesn't even exist? So, you know, there's different ways that you can kind of try to figure this out. If there's a way that you can try to figure out just who the insurance company is and maybe serve the insurance company, you know, if the company's no longer in business. But you know, it is something to consider. I think there's another slide after this that explains a little more too about this. Yeah, so what we've kind of done is broken down some of the kind of major entities that we're seeing a lot of cases with. And so just so that everyone knows, you know, under a government, if you're suing a government, you have to have a statute that allows you to sue them. So we've tossed the statutes up here, and just so you know, we're going to fly through some of these slides, but this is all part of the material, so everyone will get these. So if we could pop on to the next slide. Okay, so this is that CA case that Scott was talking about that Holly did such an amazing job on. And so this is the Seminal case for school liability. So if you have a case against a school district or pretty much any school, this is the case that you need to go read first, because it really lays out, one, how the government code applies and basically says, like, no school districts, like, you are liable. Even if you don't have a public school, this is still a great case to look at, because it talks about the special relationship that a school district has with the students. So as we all know, going to school is mandatory. You have to go to school. That is a requirement under the law. And because of that, that's what gives this heightened duty to schools. And so they talk about, you can see there on the second bullet point, is that a school district and its employees have an affirmative duty to take all reasonable steps to protect its students. So we're going to get into this in a little bit where we talk about the different causes of action. But this case is what helps explain that the duty runs to the students. So when you've kind of got your negligent supervision, hiring, retention claims, and you're talking about, you know, you've got a duty to supervise those employees, here it's so much further than that. You've got a duty to do everything possible on school grounds and even off school grounds if you're dealing with employees and stuff like that to protect your students. So, you know, you see at the very bottom there where it talks about either a total lack of supervision or ineffective supervision may constitute a lack of ordinary care. So when Holly was saying before, if you're like an ostrich and just stick your head in the sand, you're like, whoop, what? If I don't see anything, I don't know anything. Here, the case is saying absolutely not. Like, that's not how this is going to work. You have an affirmative duty to take all, reasonable steps. So Holly, I don't know if there was anything you wanted to toss in about this case as well.
Yeah. So this case, and Stuart, my partner, worked on this as well with, this is one of the John Manley and Vince Finaldi cases too, that was when this case came out, there had not been a case on point saying that an individual at the school has the duty. And that's really what I think, and Taylor, I think you're touching upon it, where not only is it that the duty runs to protect the student, but the idea is that we're not just drones of the employer, right? We're these teachers, and there is an argument as to who within the school owes the duty, but the idea is that the individual employees owe a duty, which is, as the slide before, gives rise to the vicarious liability against a public entity. So I think one of the seminal things about this case is that the Supreme Court recognized that the individuals in the classroom, the administrators, the supervisors, whoever, but they have a personal duty, not like where all of us, like let's say you go to Kinko's and the person screws up your order. That person has no duty to you, right? The Kinko's might have a duty to you as a business owner, right? But not necessarily an employee working there might not have an individual owed duty to you. In this, they're saying, yes, you do have, as a result of the special relationship that exists, the employee owes that duty. So I just want to touch upon that. But yeah, I think the very fact that Taylor just highlighted, which we use all the time, is this idea that it's not that in these cases these third parties just have a duty to manage this perpetrator defendant. It's that they have a duty to protect the kids in their care. And I think if you try these cases with that in mind, that perspective, it changes the game and it makes it a lot easier and it makes more sense, to be honest. That's what this is about. It's not about managing, controlling the perp who did the molestation as much as it is protecting minors from foreseeable sexual abuse.
Yeah, and I think that's the great framework to how to look at it, because it's not just I need to follow this perp around all the time. It's no, we cannot be allowing students to come on campus before school opens and play, and be in the bathrooms without being supervised, because it's obviously that's creating the situation that they could then be abused, because what's the problem within the perp showing up for work early? Then they'd be like, well, that's just normal. But no, it's that you've set this situation up where they would be alone with them, so it's exactly what you said. It's looking at it kind of from that different lens. So if you're not in the school situation, really what you're trying to look at too is if you're, with these third party entities, is there a special relationship? Is there, because you got to figure out, how is there a duty? Like, why would this entity owe you a duty? So, it's defined in a lot of these case law events here, but it talks about how the special relationship exists when the plaintiff is particularly vulnerable and dependent upon the defendant. So typically, particularly vulnerable, it's obviously if you're a child, so children are particularly vulnerable. It's pretty much the definition. You've got that Casey instruction that says that, there's a higher duty for when you're dealing with children. But, maybe it's that particularly vulnerable. Maybe it's that they're mentally disabled. Maybe it's they're physically disabled. Maybe it's, the client that is going through a divorce and, her attorney, takes advantage of her. Maybe it's, maybe it's in the social services situation. I mean, it's when you're dealing with particularly vulnerable people. And if we could go on to the next slide, please. They've shown it in different scenarios. So just a couple, so you guys can kind of see what I'm talking about. So for colleges, so even though you're not required to go to college as you are, to go to your elementary schools under the law, they still say there that universities have a special relationship with their students and a duty to protect them from foreseeable violence during curricular activities. So again, they're talking about, because you've got these people under your care and you're inviting them in and you're providing this environment, that you still have this special relationship with them. Next slide, please. So you also see this in youth organizations. Again, if you're a soccer organization, that's what this case is that's cited here. You are hiring the coaches, you are hiring the staff, you are putting the kids in certain situations that that it says right there, based on the vulnerability of children and the insidious methods of sex offenders, the court held that there's a special relationship between the scouts and the plaintiff. This is a quote from the youth soccer organization, using it to hold the soccer organization liable. And here they're referring to the Juarez case, which was saying that just like Boy Scouts, like you have this special relationship with these kids. It's the same as the Boys and Girls Clubs. And so again, you can apply these cases to all sorts of organizations. Next slide, please. So Holly, this is so important. So we're talking about special relationship. And so why don't you tell us about this case, Brown versus USA Taekwondo, that's up in the Supreme Court, and what this framework is for us in our cases going forward.
So there's a case right now before the Supreme Court that the issue being addressed by the court is, what is the duty? What is the test for the duty owed by a third-party defendant to a minor to protect that minor from against sexual abuse by a third party? So I don't know, how it's going to come out. It's going to be huge, no doubt, in all of these cases. We're doing an amicus brief on it, and I'm hoping it stems from a Court of Appeal decision that kind of mixes up these ideas. There's been 2 or 3 Court of Appeal decisions that kind of mix up this idea of special relationship with kind of roll-in factors, with and not necessarily appreciating that they're minors. So I don't, it'll be interesting. I'm hoping that that the Supreme Court sees this and recognizes that the duty owed, and in this case it concerned athletes of the Taekwondo, and it was a case against who had been molested by their coach. And it was a case against the national group as well as the Olympic Committee. Court of Appeal found national group had a duty because they could help control the perpetrator, the coach. They could take away his license, they could do whatever, they could require him to do certain things. The Court of Appeal said no duty owed by the Olympic Committee because they're too far off. They are not really in the best position, quote unquote, to be able to protect these minor athletes. I think that analysis is mistaken. I think really what this is about is the sex abuse foreseeable, and can you do something when you're talking about minors? Are you in a position to help protect against it? Which the Olympic Committee was 100% in a position to be able to protect minor athletes from sex abuse. And we know from all of these recent cases that this is not a one-off. This is happening. It's happening all the time, and it makes sense because you have, a young minor athlete who is being pushed, do the best they can. Their parents drop them off for practice. They stay there for 6 hours with this adult coach. This is kind of ripe for sex abuse. So the way, I don't know how this is going to come out. What the court is going to decide is what's the appropriate test? What do we look at for the duty? And so, obviously we have Civil Code 1714, which is everybody owes a duty to each other, right? It's not that you have a duty to act necessarily if there's not otherwise one there, but it's that you have a duty to act reasonably in what you're doing. I think in this case, I think our arguments are going to be really focused on this idea of special relationship, the fact that the Olympic Committee is, pretty much providing the platform for this, and they're making tons of money from it, right? So the idea is, they can't be, creating this platform for where the abuse occurs and then just turning their head and saying, well, we don't owe a duty to the minor athletes that are going to be foreseeably could be sexually abused. So
well, it goes back to that mindset you talked about earlier, which is the duty to actually protect the children versus the duty just to use reasonable care in general.
That's 100% it, Scott. And that's what to me is so frustrating about the lower court opinion, or the trial court, Court of Appeal opinion, is that it really focuses on, well, what could they do with this coach? What could they take as, and it's like, the idea is the minors. And do you have any way to control that? Can you do something in your power to protect against foreseeable sexual abuse? And the allegations in this case are horrific. People actually knew this guy was sexually abusing 15-year-olds, like multiple 15-year-olds, right? Like there was actual notice of it happening. So I think that's 100% right, Scott, is that the idea is, let's get out in these cases, let's get out of this idea of wanting to put it into a traditional negligent supervision of an employee type situation, and let's put it into special relationship, duty flowing to the minor, and maybe they acted within the reasonable care. Like a lot of these, maybe AYSO in some of those cases, they vetted the best they could. They said coaches aren't allowed to be with students one-on-one. Who knows what, we could make up some stuff and be like, okay, that's okay. You reasonably did what you could within your control. But to say no duty, which is a policy-based ruling, and say we're gonna alleviate any duty owed by an organization is next level. And I'm a little worried, candidly, that because we have 340.1 expanding the statute of limitations so big, there's going to be some effort to kind of contract liability in some way. I don't know if this would be it, but I want to make sure that we don't end up in a situation where we take 10 steps forward and 15 steps back and then kind of are stuck. So that's coming.
If the analysis is simply a negligent supervision analysis, then at least the way I look at it is you're advocating the ability for them to just stick their head in the sand and not do anything.
Right.
And I think that's really where the focus has to be with the court, is you can't allow them just to stick their head in the sand. You have to come up with a bright line rule where they have to take affirmative steps to protect the minors that are in their control and custody.
Yeah, and I mean, think about it too. I mean, it's they're holding out to the community. We are the Olympic Committee. We are the best. We are giving you the best training staff, the best coaches. Like this is, they're holding these people out to be amazing. And it's kind of similar to the church cases. It's like, oh, look, this is the stand-up priest. Like he's, such a good guy. You can trust your kids with him. Like he is, close to God, blah, blah, blah. And then it's like, oh, okay, like we found out this one isn't so good. Let's just move them down the road to a different school and like see what happens. It's like we can't just let these big entities just be like, whoa, what were we supposed to do? Like we're not the boots on the ground. Like we're not the ones that are, supervising this perp every day. So I think it's going to be super interesting to see how it all comes out. So it's just something that everyone should just kind of be aware of, to keep their eye on, to see, because that's probably going to change how we plead some of our cases and argue some of our cases going forward. Okay. Oh my goodness, I can't believe our timing. Okay,
I was just gonna say, let's make sure we hit as many of these points as we can, so we leave a little time at the end for questions.
Yeah, so I'm gonna kind of blow through some of this kind of fast. And Holly, interrupt me at any point in time on some of this stuff. So what to plead? Here are kind of the general big ones that we use in a lot of our cases, but there's so many more causes of action. So don't just only do these, look at your case, call Holly or I, and we're happy to kind of give you some ideas. But I just kind of wanted to touch on some of the biggest ones. And if we could go to the next slide, please. Okay. So this goes back to what we've kind of, if you can notice a theme throughout this whole talk so far, is this negligent hiring, supervision, retention versus negligence. So the defense is 100% going to want to get you stuck in this negligent hiring, supervision, and retention. If we go to the next slide, please. And the reason for that is because under these cases, it is a person in a I can never say this word, so I'm going to skip it, position over an actor had prior knowledge. So what does this mean? This means that it has to be an administrator. It has to be a supervisor that knew that something was going on. So for example, let's say at a school, you've got a first grade teacher that sees another first grade teacher taking a kid into the classroom and shutting the door and like closing the blinds. Okay, that right there should be a siren, red flag, something's wrong, this cannot be done, right? Well, if that teacher never told anyone, the school would not be held liable for that under this negligent hiring, supervision, retention, because that first grade teacher was not a supervisor of the other first grade teacher. So you can see where this is it's basically a heightened negligence rule. So I hate it. So what I like to do, if we could go to the next slide, is I plead all my negligence theories as one cause of action. I don't split them up. I try to just put everything in one big, cause of action one, negligence. Oh, no, go back, sorry. And I lay it all out in that. And why is that? Because as we saw specifically in that Hart case, remember that we talked about the duty runs to the student. They have that affirmative duty to supervise the student. So under these cases, especially for schools, and you can apply them in other cases as well, that the school district can be vicarious liability for any employee's negligence. So now remember, we're not talking about the perp employee, or what we're talking about here is we're talking about the fact that that first grade teacher saw the other first grade teacher do this. That school district can be liable for the first grade teacher that saw what happened and didn't report it. This is the same thing under mandatory reporting. So if you didn't report, reasonable suspicion of child abuse, the school district can be liable for the fact that you didn't do that. So that's why I like to plead it as one big negligence claim so I don't get stuck in it. So next slide. And this is just a quick blurb of, when you've got a demur, how they can't knock out, your cause of action if you've got some theory of negligence in there. So this is what I use to argue to the judge of like, look, you can't knock me out because about a supervisor or anything like that. It all gets to stay in there as this one cause of action. Now, some courts are pushing back and saying you've got to plead them separately. And so if you do, you do. But, for now, I suggest pleading everything as one cause of action. Next slide, please. At the same time, I will tell you, and we were all, I hate to say this out loud, and hopefully this judge is not watching or no one reports back to him, but I just got a ruling on JNOP that I did not plead enough for negligence. I've never seen that. Negligence is such a broad, topic. So I do add some little facts. It just kind of depends on what your case is, but always contact Holly or I, and we can kind of talk to you about that. Especially because sometimes if you've got these cases back in the 80s, a long time ago, you might not know all the facts yet, or like all the witnesses or documents or anything like that. So just remember that, negligence should be a pretty simple cause of action to plead. Civil codes. Okay. I think civil codes are very important, and I think they're often forgot about. With the civil code, and we didn't go into all of it here, but if you look under 52, Civil Code 52, it lays out all the various types of damages that you can get under these code sections. So some of them are attorney's fees, exemplary damages, so you can get a lot more under these civil codes. So I think they're very important to plead. Again, I'm gonna kind of breeze through this unless Holly, you want to jump in, but this is, some of the different codes that are there, and it gives you, you can look at this law later on your own. So we could go to the next slide. This is the 51.9. Typically I use this in most of my cases if I can. the only thing is here is that the person, the perp, you've got to be in a professional relationship. So it talks about some of these physicians, attorneys, landlords, teachers. So it does have a little bit of a nuance there, but we do try to use these as much as possible. Next slide, please. Okay, so this is how you're getting the entities on the hook for the perp's actions. And it's through this ratification, aiding, and abetting, which is specifically laid out in 52. So it says whoever denies, aids, or incites is liable for these civil code violations. So, it's that, they knew that this employee was doing it and they didn't do anything to stop them. They had received credible reports. I don't know, Holly, is there anything else that you kind of wanted to add to this, or should we just kind of move on?
Yeah, I think it's there. You've got ratification, go for it, but yeah, I think,
Yeah, it's your typical aiding and abetting type of, information. I mean, so we've used it in like hospital cases, if you're still providing them access to patients, if you're still giving them surgical privileges, whatever it may be. There's a lot of different ways you can use it, but definitely something that you want to do because you want to get those heightened damages. So next slide, please. Okay, mandatory reporting. Holly, do you want to take this one on, or
yeah, just a really quick note, because I think you already touched upon it, is that a mandated reporter has to, which includes people, working at a school, even like, I think we had one case where it was like a lunch lady we were able to establish was a mandated reporter, and they were, if they suspect child abuse, reasonably suspect child abuse from an objective standpoint, so whether or not an objective person would suspect it, they are required to report it. And it's really good because, like Taylor was saying, it can be the negligence per se, it can be the foundation for your negligence, for your vicarious liability cause of action. I think it's always great to include it in there, so definitely pay attention to it, allege that who's a mandated reporter, allege that they failed to comply, all that good stuff.
Okay, next slide. Okay, false imprisonment, I tossed this one in here. So, when you're dealing with situations that are happening in the home, especially, and you're trying to trigger that homeowner's insurance policy, which it can be pretty difficult. And we didn't get into it in these slides because the notice requirement on behalf of like the spouse, for example. So everyone's probably thinking, oh, well, don't worry about it. I'll just get it under the negligent supervision of the spouse. Well, it's a heightened standard kind of for notice than your typical like school district cases. So it's a whole nother bag of beans. So we could spend another 6 hours just on that. But in terms of just trying to figure out, again, we're talking about, the defendants and what you can plead and, at the end of the day, like you're trying to get money. So what are you, how are you going to plead, especially under these homeowners insurance policies that have specific exclusions for sex abuse? And a lot of people have been able to get around that with using the cause of action of false imprisonment. So that's why I put it there. It's something just to kind of think about and tool around with in the back of your head. So next slide, please. Okay, treble damages. This is huge, huge. I know this is so amazing. This is, talk about when Holly was talking about when this 340.1 came out and all of a sudden the treble damages was in there. Like we couldn't believe it. And it's funny, I was actually talking to someone yesterday who's, we're going to be on some priest abuse cases together. And he was one of the ones, him and his firm were one of the ones that, pushed this bill through. And he was like, yeah, we tossed in treble damages kind of thinking like, okay, maybe that's the one that we could give up on, or whatever, like we would let that go, kind of to negotiate. And it went through and it's absolutely, absolutely amazing. So Holly, why don't you give us a little bit, a quick touch on how we're using treble damages and especially with government entities.
Okay, so treble damages, I think this is a big, big change like you just signaled. And yeah, I was so surprised that this made it in the bill. And I think it makes sense. I think the reason why it's in the bill is because of all these news stories that, like I said, all of you guys that work in this area are bringing it to the media, bringing out, what used to be, kept in by victims. We're showing, no, this is an institutional, systematic, I know I just messed up that word. Anyway, it's all over the place. So I think that the treble damages could definitely come in a lot of these cases. And what it is 340.1b, I believe, says that where the plaintiff was sexually abused as a result of a cover-up. So I want to focus right there on that language, because that means that that the abuse was a result of a cover-up. So if you have a client that was sexually abused and then they covered that up, right? So the school then hides all the info, they deny it happened, you know, et cetera. That would not entitle you to treble damages, because your abuse was not the result of a cover-up. You were the cover-up, right? So in that situation, you wouldn't get this. It'd be great for damages and everything else, and you know, notice and everything, but it wouldn't entitle you to treble. Treble is where you have a case where before your victim was sexually abused, or around the same time, you know, whatever you have, there was evidence of a cover-up, and so usually that's going to involve other victims. The way the statute defines cover-up is amazing, and I want to get this right. I believe it's that cover-up is, quote, a concerted effort to hide evidence relating to childhood sexual assault. A concerted effort to hide evidence. Okay, to me, this is, you get an email, the principal gets an email about something, deletes it, right? That to me seems like a concerted effort to hide evidence. So I think the very fact that the statute is defining what a cover-up is tremendously helpful and will really benefit, because I think just about anything can fall under that category. And you know, anytime that they're not reacting to these reports, a lot of times we'll see like SCARS reports, or you know, something will come in and they'll just kind of like pat the person on the head and be like, okay, don't do anything, and then cover it up, and then it's not kept in a file where the next report that comes in, the new principal has no idea about the old report, right? So there could be these situations where you have a cover-up and a hiding of evidence. Treble damages is basically where you take 3 times the compensatory damages. And so one of the big issues that's coming up right now is whether or not it is punitive in nature. Because as we know, you can't sue a government entity like a public school district for punitive damages. And that's Government Code 818. And so the argument here, and I've had 2 so far, I think the 3rd is pending, but 2 so far where we've been successful in arguing that this is not a punitive remedy. This is not punitive damages. This is different because of the compensatory element of treble damages. And when you look at the legislative history, you can see that the reason that they're even providing treble damages for a cover-up is because imagine the victim's harm. You've been victimized, you've been sexually abused, and then you learn that it was entirely preventable, that the institution you went to, the church, the whatever it may be, actually knew this guy was out there doing this, or woman, and covered it up, which led to you and other victims. So there's kind of another element of harm that a victim may suffer in that situation. So those treble damages are compensatory, at least in part, taking it out of being purely punitive, therefore taking it out of Government Code 818. So that's one. The other thing to be aware of is that there's some arguments by defendants that it violates the Constitution as an ex post facto law, and that it's basically providing a criminal penalty retroactively. So we have some arguments against this. It's a very technical constitutional argument, and I think it's wrong. I think that those are really reserved for like criminal. It's basically when a civil statute is really criminal in nature and just being disguised as civil. And I don't think you could say that that's what this is. And it's got to be clear. So I'm not too worried about it. I don't know. Just a heads up, I think in one of the cases I have that they've taken a writ on the issue. So there's nothing that I know of that's currently before this Court of Appeal on treble damages, whether or not it can be retroactive, whether or not, you know, all these different things against a government entity. But I imagine that it will be coming up in the next year. So
So Taylor, in about the 15 minutes that we have left, why don't you sort of take, sort of the framework of what we've talked about and talk about some of the evidence that you developed in the TH case. I know there's some folks that want to hear about that and how it ultimately led to the $1.75 million settlement and the overall settlement with everyone.
Yeah, for sure. So, evidence in these cases can be kind of funny, especially with school districts. And it's something that I don't quite understand, but they will have files everywhere. So there will be like, an employee file, right? So typically you think like, okay, so, teacher A, there is at the district office, there's teacher A's employee file, and it has all their write-ups, all the information, everything that's ever happened to them is all in that file. That is not the case. You'll find out that then the principal had his own files, which had some like weird stuff in it, but then that file might have not been given to the new principal, so then he might have something different. Then there might be a paper file versus a file on the computer system. There's truly stuff everywhere. So make sure that, when you're asking for these documents and then when you're going and taking these depositions, dive into the, okay, well, is it a computer file or a paper file? Do you have both? Do you have one? Do you have this? Do you have the other? And what ended up happening in our case is that, and I'm not going to blame this on the lawyers, because we all know that sometimes we ask our clients for things and they give us something and they don't tell us about this other, file that they may have. And through the deposition, it came out that this principal had a whole nother, like, basically hodgepodge of documents. And so they, then it's out in the open now, and the lawyers had to go through it. And through that, they found a bunch of other documents that really helped us in these cases. One thing to keep in mind too is to, try to work with the DA if you can. Some DAs are easier to work with than others, and I don't blame them, because a lot of times plaintiff lawyers have royally screwed their cases for them. And so I just would say, as a plaintiff's lawyer, if you're representing a victim and the perp is being prosecuted, please, 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 please be aware of what you're doing, because you can end up affecting the criminal case, and you don't want to do that. So just something to keep in mind. Also, the California Teachers Association. Remember that, teachers can get access to representation through that Teachers Association, and they also might have files as well. So think of your FOIA requests too that can go to different places. Even your FOIA requests that can go to the district before you even sue them. There's many different avenues that you can go through to get documents. If you have a police case, God bless you. Holly and I will talk to you about that another day, because those files are a nightmare to try to get, so that's different. But just, I hate to say it, but be a dog with a bone. You just got to keep on keeping on. If you have a really big case and it's worth the money, and you're able to get an investigator that can maybe go through like the yearbooks, or your client can kind of give them some information, and they can end up kind of going down this trail. They can do a Facebook sweep, things like that, to see if they can find other people that can corroborate what happened. That's another thing too. So let me show you some of the evidence. So if we can go to the next slide, please. Okay. So what happened in our case is, you see here that there's a memo that was all the way back from 2004. Remember, our stuff happened a few years ago. So this was all the way back in 2004, where Teresa Hollis was a secretary at the district office, and John O'Brien was the principal. And here she is writing a memo to him saying that she received this phone call. She gives the date, she gives the time, and she says it's a young male adult. And he asked if there was a teacher at the high school by Snyder, and started talking about how, he was abused by Snyder. So she wrote this full memo about it, right? And here it shows that she gave it to the principal. Well, as you can imagine, at the school, that they did everything possible to try and deny this. So, when I would ask, okay, so you get this report, like, what did you do with it? Like, who did you contact? Who did you tell? Like, or basically, did you do what Holly said and you just go, ooh, this is a fun memo. Let's go stick this like somewhere else, And I just kept getting back, you know, well, we didn't know his name. We didn't know his phone number. We had no contact with him. He called this one time and said this one thing, and then we were never able to get in contact with him again. Well, you know, that's crazy. You know that that's not true. And so we had to kind of keep digging. So if we could go to the next slide, please. Okay, so here you can see that in this, so this is from 2007. So this is what we found from the California Teachers Association. This was a request from Snyder, the perp, who went to the Teachers Association and said, hey, I need a lawyer because a kid from a while ago is accusing me of abusing him. So think about this. How would the perp teacher know that a kid was accusing him of abuse? The only way he would know that is if the school told him. So clearly, the principal read this memo and either talked to other people about it and then went to the perp teacher. So didn't go to the police, didn't alert anyone at the school, didn't take any actions other than to go warn the perp, hey, you know, there's a kid that's saying that you molested him. You might want to go get a lawyer and go ahead and start trying to quiet this down. I mean, that's bananas. I mean, I can't even, like, I would just sit in the depositions and be like, you guys are sitting here with a straight face right now and telling me this, like, aren't you embarrassed? Like, you know, sometimes you look at these people and you're like, you know, look, I'm not saying you got to admit guilt, but at some point, can't you just say like, oh, my bad, like, oops, like, I don't know, something. I mean, but it's like, you sit across from the table from these people and you're like, you're effing lying. You are lying to me when you say that, oh, we got this memo, but we didn't have enough information to do anything about it. Are you kidding? Like, as a school with kids in your classrooms day in and day out, and with this man that you have working with these students, I mean, God, you could have even just been like, we're not really sure about this. We don't really know what's going on. Maybe we don't have information that we can use to help track this guy down. But, you know, I tell you what, we're going to have, you know, another teacher go and monitor this stuff every single day just to make sure there's nothing wonky going on. I don't know. It's just anything that you could do. But no, once again, it's like, oh no, let's go warn the perp because that's the person that needs the help here. So anyway, next slide, please. So again, when they had to go through these other files and things they found, this one kills me. Like, this is when I was like, you guys are the biggest liars that I've ever met. And here, this is, you know,
How do you really feel about it, Taylor? How do you really feel?
Oh, it just makes me so crazy. Like, it's like, oh, I don't know. It's as a school, your whole entire being is about protecting kids and making them these amazing human beings in the future that can help our society. And it's like, then you're just like, but if they get molested along the way, like, no big deal. Like, that's just what absolutely, it makes me nuts. So clearly, like, I'm not the one to ever talk to if you have kids and you're gonna send them to school. Like, but anyway, so but this kills me. So this is from a memo from the principal to the perp. Remember, to the perp, that a detective from the police department was calling to talk to him. And then at the bottom, you see that name? That was the name of the guy that was calling and complaining. So for them to say, the school district to say, oh, we didn't have the name, we had no way of reporting this information to the police or to anything like that, there it is. How did you get that name? It just randomly popped into your brain? Like, it's complete BS. And even Teresa Hollis, God bless that woman, because she came forward and she was like, absolutely not. I told them who it was. My kid was even in school at the time that this reporter was, and I went back and looked in the yearbook to see if I could figure out who he was. So she was like, no, I told them all of this information. And clearly they had it all because of all the other things that they were doing behind the scenes to alert the perp. And I'm sorry, if a detective is calling your school, don't you think like, maybe this is something we need to kind of like look into and figure out and kind of understand what's going on? And of course not. And they didn't. It's the craziest. But again, all these documents came through multiple rounds of depositions and just kind of diving in and asking for, where do you keep your files? Do you have a file here? Do you have a file there? Because of course, at the beginning of the case, when we asked for the personnel file, and you get this very bare bones bullshit, file of just like, oh yeah, we checked his references, like, oh yeah, he did this thumbprint background check, and and it's like, and that always kills me. It's like, oh, well, we did the background check, what else are we supposed to do? And it's like, well, yeah, because he's been abusing people for the past 10 years and nobody's ever reported it. So of course he's not going to show up on this background check, So it's like, I hate that argument of, oh, we did the background check, like what else are we supposed to do? And it's like, well, you're supposed to supervise the students. This is where, again, it comes back to what Holly said. It's the frame of mind when you're doing these cases. It comes back to the supervision of the students. It doesn't matter if you're a nun, if you're a priest, if you have gotten the best recommendations from everyone else in the world. You can't just let these people have unfettered access to students with doing zero supervision. That's why they talk about in preschool classes, like kids do not sit on teachers' laps. You do not go into a classroom on your own with doors shut. This is, what was it, that Jennifer M case, or Jennifer C case that talked about the alcove on the property? That's like, you can't just have this random like alcove on your property and not, inspect it or have it closed, because as we can all imagine in our heads, what happens at a school in kind of a place that no one can see? I mean, it's all these, foreseeability arguments that you can make. So that's we got all this good evidence, and I mean, they just really, there's nothing that they could do about it. It did help, obviously, that he was being criminally prosecuted. And of course, there's things that the police can get that we can't get. A funny story, or two funnies, it's not funny, it's actually super sad, but I'll give these two quick hits. The perp at the criminal hearing, this is how massively messed up this man is. His family stuck with him through this, right? So his daughter is sitting in the front of the criminal courthouse, and he's up on the stand testifying, and he blames all the pornography, which, by the way, was like sex with little boys, like little small kid pornography. Like the search terms that he used was just bananas. And he said that was because his daughter was going to the dance with a friend who was a homosexual. And so he, since he's a teacher, he likes to use visuals. And so that's why, he had this on his computer. I mean, it's just like, oh, like, could this guy be any more of a creep? And I mean, to blame your own kid, I mean, it was crazy. So anyway, that's my rant for this morning, and I'm sorry, I can get really fired up about it.
No, that's all right. I mean, but it's interesting to one of the things that everyone needs to keep in mind is that the fact that he was prosecuted criminally certainly helps. But remember, that helps us to the case against him. The case against the school district was only as a result of the dogged investigation that you did, the discovery going beneath, going above and beyond what would be the typical discovery, such as asking for the personnel file and getting these other documents, which is what tied the school district to their knowledge of what he had done in the past and their failure to protect the students. And so, when you're doing these cases, you have to keep in mind that it's really a two-pronged thing, which is one, what did the perpetrator do? But secondly, what did the district know and when did they know it? Or what did the organization know and when did they know it? We only have a minute left, but there are a couple of questions. So if I can ask you real quick, somebody had asked Paul Kang, one of the attendees, what specifically should you not do to mess things up for the district attorney? So I know you talked about that earlier.
Yeah, so just remember that anything you do in your case, that especially if you have the perp in your case, that's going to get into his criminal defense lawyer's hands. So if you're taking depositions, you got to be real careful about which depositions you're taking and what they have to do with your clients, especially if you have younger clients. Do not be interviewing them. Do not be asking them a ton of questions. Do not be sending them to psychs yet even. I mean, yeah, it's one thing if they're seeking therapy, but don't be sending them to other people, because the first thing they'll do when they get on the stand is, hey, like, you've actually talked to multiple people about this, and they'll imply that everybody else is what has put this in their brain. So, you know, you just have to be really careful, you know, about doing certain things that, you know, because there's things that we can get in the civil case that they can't get in the criminal case. So especially if your client has got, you know, a traumatic background, you know, be careful about what documents are coming out yet or what you're producing and things like that. And sometimes it's better to wait until after the criminal case is over before you even file your civil case. But sometimes with statute of limitations, that's not always the case. But just remember, if you do that, just send an evidence preservation letter.
Yeah, and that's the point I was going to make as well, Taylor. You know, sometimes the mere fact that the victim has a civil lawyer in and of itself is used against them in the criminal case, because that lets the defense attorney in the criminal case argue that it's solely for monetary gain, that he's being prosecuted in order to help put money into this kid's pocket. So again, if it's possible to wait until after, the DA is more likely to cooperate with you if you're sort of helping him behind the scenes and haven't filed yet, versus if you do these other things which could potentially mess up their case. But obviously, if the statute of limitations is an issue, or there are other extenuating factors requiring you to file when you have to. But just sort of take all of that into account. So our time is up, and again, I so appreciate all of you who attended. The PowerPoint is going to be made available for all of you. Taylor and Holly, you did a fantastic job. Thank you so much. This is such a complicated area, and you just made it so easy for everyone to understand. Certainly, if you have any questions, you can reach out to me or to Holly or to Taylor. We'll either answer your questions for you or be able to get you to somebody who can. But I wanted to remind you also that, again, on October 1st is our next program with Rob Jarchi and with Christian Nickerson to talk about the Padilla versus SCE case, which resulted in the $4.7 million all general damage verdict for an undocumented worker. So thank you all again for attending, and we appreciate it.
Thank you.